Okay, I want to thank everybody for coming tonight. I want to wish you all, I guess, a happy Constitution Day. Is that proper? It's actually, I just found out today, it's actually, the name has changed. Some time back, way back in like 2004. It's now the Constitution and Citizenship Day. So they kind of broaden the scope, I guess, of activities that can be carried out. In one of the, as I say every year, in one of the paradoxes of our political system, we are mandated to celebrate the Constitution because we are an institution who receives financial aid from the federal government, and all institutions that do are expected. In a bill passed by, or led by Senator Robert Byrd, former senator from West Virginia. If you don't know about Senator Byrd, you should look him up. He's a real interesting, was a real interesting character. Want to introduce the panelists tonight. To my far right is George Lange III. He is from the Department of Criminal Justice, History, and Social Sciences. This is Mr. Charlie Penrod from the, what is it called now, School of Business?
School of Business.
From the School of Business. A couple of attorneys here, so keep the jokes clean. Myself, I'm Greg Granger from the Department of Criminal Justice, History, and Social Sciences. I teach history and political science. Before we get started with the real heavy substance of tonight, what we're going to do is we've each picked a couple of court cases that have been decided by the Supreme Court in the recent session. And we'll kind of pick them apart, tell you a story, and open up for questions, make some commentary, and have some fun. Before I do that, however, just a couple of fun facts. I want to thank George for pointing out there's a real helpful website if you're ever doing research about the Supreme Court. Besides the Supreme Court's own website, there's one called SCOTUS Blog. SCOTUS means Supreme Court of the United States. It's the acronym. SCOTUS Blog is a very helpful website, and they gather, for one thing they do is gather statistics. Things weren't too unusual this year. There were a total of 78 decisions that the Supreme Court has decided. That's pretty much in line with recent years, last 10 years or so. Keep in mind, thousands of cases try to make it to the Supreme Court, and roughly 75 to 100 do. If you're lucky, it's 100 or so. So not many cases are actually heard by the court. This is the what we call the Roberts Court. John Roberts is the Chief Justice of the United States. And through his term so far, there have been 65 to 75 decisions. So we're pretty much right in line with most years. Interesting, a couple of more, 72%. Most cases get to the Supreme Court on appeal from what we call an appellate court, a second level of courts. 72% of the decisions reversed the lower court decision or vacated it. These guys can define that for you in just a minute. 28% of lower court decisions were affirmed by the court. 31%, which is a little bit more than usual, I believe, were what we call completely unanimous. That is, none of the justices wrote what's called a concurring opinion. Some justices agree with the decision of the court, the majority opinion, but they write a concurring opinion. They have something else to say. They agree, as one person, as Ginsburg puts it, I agree with the judgment, but not the opinion. She has her own opinion as to why she voted this certain way. Those in a minority often write a dissenting opinion explaining why they voted the way they did. So 31%, about a third, completely unanimous. Might be a little bit more than usual. On the other hand, there's a lot of talk over the last several years of the 5-4 split in the Supreme Court. And the general rule is that there are 5 conservatives or 4 conservatives and 1 slightly center-right conservative and 4 liberals. However, 29% of the court cases this year were decided on a 5-4 split. However, look up this little essay for yourself. It's interesting how there were 11 different combinations in that 5-4 split throughout the session, which means the coalitions we expect to be in place, the conservative versus liberal, it's a little more complex than that. We saw more cross-ideology decisions, I think.
We saw a lot of wheeling and dealing.
A lot of wheeling and dealing. Okay, we saw, let's put it in lawyer terms. We saw a lot of negotiations, shall we say. A lot of interesting topics from college admissions to same-sex marriage, technology and the law, using a 223-year-old law to prosecute Shell Oil Company, which didn't work. We'll talk about that in a minute. And search and seizure, Fourth and Fifth Amendment cases, on and on. So interesting selection and very important selection of cases this year. I think in the last few years, sometimes we focused on one big one, like the healthcare decision or Citizens United. Those are two big decisions that came out of the last couple of years. These, I think, were spread across the board of topics a little bit more. So, having said that, who wants to go first? You guys roll the dice here.
I'll take one.
George? Okay, George, why don't you go? Tell us a little bit about what you're going to tell us about.
I'll tell you a little bit about what I'm going to tell you about. One of the cases that I selected has to do with search and seizure. And the reason I selected it is because the Supreme Court really did, I won't say an about face, but it substantially changed the state of the law, particularly for criminal lawyers. It has to do with whether you have probable cause for a search. Let me read you the scenario because it's very interesting. In 2006, Detective William Pedraja of the Miami-Dade Police Department received an unverified tip that marijuana was being grown in the home of respondents Jardine. Jardine was the fellow who was ultimately prosecuted. 1 month later, the police department and the Drug Enforcement Administration sent a joint surveillance team to his home. Detective Pedraja was part of that team. He watched the home for 15 minutes and saw no vehicles in the driveway or activity around the home, and could not see inside because the blinds were drawn. Detective Pedraja then approached the home accompanied by another detective, who was a trained canine handler who had just arrived at the scene with his drug-sniffing dog. The dog was trained to detect the scent of marijuana, cocaine, heroin, and several other drugs, indicating the presence of any of those substances through a particular behavioral change that his handler could easily recognize. Detective Bartlett had the dog on a 6-foot leash, owing in part to the dog's wild nature and his tendency to dart around erratically while searching for drugs. As the dog approached the front door, he apparently sensed one of the odors he had been trained to detect. Which one do you think he sensed? Marijuana. And began energetically exploring the area for the strongest point source of that odor. As the detective explained, the dog began tracking the airborne odor by tracking back and forth, engaging in what dog handlers call bracketing. He went back and forth, trying to center on the source. Finally, he got his little nose right by the front door. Well, the dog handler realized that his dog had alerted. So after the dog alerted, on the basis of that alert, they applied for and received a warrant to search the residence. They searched it. What did they find? Marijuana trees. And Jardine was promptly prosecuted. He was convicted. Despite his motion to throw out the evidence of the marijuana because it was based on the drug dog's sniff, which he characterized as an unlawful search. That was the issue before the Supreme Court. Could a police officer, a dog handler, go on the front porch of a home, have his dog sniff the odor, and did that constitute an unreasonable search? Now, what you have to remember is that around 1967, the Supreme Court materially changed the state of the law with respect to searches and seizures. Before a case called Katz v. United States, our search and seizure law, our Fourth Amendment protections, were based on the old common law trespass law or property-linked law, meaning that if government agents didn't intrude on one of the 4 things named in the Fourth Amendment, persons, property, papers, and effects, there was no search. Katz said not true. Katz said the Fourth Amendment protects persons and not places, meaning that little umbrella of protection of the Fourth Amendment goes where we go. So the issue then became, did one have a reasonable expectation of privacy when government agents intruded upon wherever you happen to be? And that was the issue here. Last year, the Supreme Court decided another case in which federal agents attached a GPS tracking device to a car. The car was registered to the wife of a suspected drug dealer. The car was used exclusively by the drug dealer. And the GPS device was used to track his movements to and fro the city. Based on that evidence, he was charged, tried, and convicted. He claimed, too, that it was a search. Now, under Katz, the prevailing law at the time, he had no reasonable expectation of privacy. He was driving on public streets. You and I have no privacy on public streets. We can be observed by anybody. But the Supreme Court changed the law again and said, nope, we're going to go back to the old property-linked rule, the old trespassery rule. If police trespass on your effects, which the car was, it is a search. And in that case, it was an unlawful search. And just as in that prior case with the drug-sniffing dog, the Supreme Court ruled that the porch was part of the house. The house was protected by the Fourth Amendment. The police had no right to be on the porch with a drug-sniffing dog, and that was a search. They threw out the search. They threw out the marijuana. And Mr. Jardines went home happy. I can see by the looks on your face it was much more interesting to me than it was for you.
But do you feel this sets a precedent for some time to come, or are they going to change it yet again?
No, I think that it's what it does is it creates a legal situation where we simply have to wait for the Supreme Court to decide cases in the future. This business of trespass law, in addition to reasonable expectation of privacy as the two standards for searches and seizures, really opens the door to all kinds of fact scenarios where police are going to have to just wait and see.
That's what I was going to ask next, was how is this going to affect law enforcement? What guidance are they given now?
Well, they're given the guidance to get a warrant.
Before they enter even the yard?
That's right, to get a warrant. It's always the safest thing to do. The Supreme Court has declared time and time again that searches and seizures are per se reasonable under the Constitution if you have a warrant. And if you don't have a warrant, they are per se unreasonable. And that's one of the great protections that we have.
Of course, drug sniffing dogs have been used for decades.
They have.
What about, again, two problems. One, Air Force, like luggage, for example, that's certainly personal, and you're not going to get a warrant to open every piece of luggage unless a dog or some other method, in any case, it's possible drugs in there. And another scenario, I dealt with drugs. What about bomb sniffing dogs? What do we do? Is that going to, is that same standard going to apply to obviously some dogs? That dog had smelled, a bomb sniffing dog, and smelled bomb-making materials in that porch.
Yeah, well, there are two things. One, I mean, of course, they never make you give the bomb back.
No.
They never make you give the drugs back. I suspect, I don't know, but my suspicion is that they're probably going to find an exception, maybe an exigent circumstances exception. We all know that there are just a whole lot of exceptions to the Fourth Amendment.
Do they have like basically a warrant ready right there? If they're, I mean, isn't there something like that where in the drug sniffing dog situation in an airport there is like an immediate action, an immediate warrant of some sort?
I
Or
don't-
maybe
I
an
don't-
overarching?
I don't
warrant?
think so. I mean,
Yeah.
just a standing warrant, no.
Yeah.
That's
I
not
can't
legal.
have that.
Because you have to describe with some particularity.
Terry, you had a question or
What
comment?
was the vote on that? Did you discuss that?
The vote on it, yeah, let me tell you what the vote was. Thomas, Ginsburg, Sotomayor, and Kagan were in the majority. Kagan also filed a concurring opinion, in which Ginsburg and Sotomayor joined. Alito filed a dissenting opinion in which Roberts, Kennedy, and Breyer joined.
One of the interesting fun facts also released was this year, Thomas and Alito disagreed more than ever before. These are two guys that are normally in lockstep. The last several years, the percentage of time that they vote together was always very high. And actually, they were not number one this time. I think Sotomayor and Ginsburg may have been, or something like that, on the same scene.
Yeah.
And, and one thing about Scalia, he tends to be very conservative in his opinions, except when it comes to search and seizure cases, which he's very surprisingly pro-criminal defendant. Oftentimes, you'll see him with the 4 liberal justices. But let me ask you this, and you may have said this in your discussion.
Yeah.
It seems to me the problem that the court found was that the officer was on the porch where he did not have a right to be.
Correct.
It seems like if you're a sneaky law enforcement agent, what you do is you don't go on the porch, you let the dog go on the porch and have that 6-foot leash where you're off the porch and let him go on the porch. I mean, do you think that would be a way for an officer to get around this by saying, I was never there, the dog went there?
I don't think so. In the majority opinion, I mean, the justice went out of his way, Scalia, who delivered it, to say that the officers had 4 feet on the porch, and the dog had 4 feet on the porch.
Ah, okay.
So I don't think so. The dissenting opinion, I mean, it was interesting. They pointed out that police, there is a limited license that we have that allows anyone to come up to our door. I mean, that's not a trespass. That's not, even a police officer can come up to your door without a warrant just to ask a question. See if you're home, see if you'll talk to them. What the majority said, however, was that it's not sufficient to have a license to be in a place. Intent also matters.
Why are you there?
So while a law enforcement officer can walk up to your door not with the intent of speaking with you, he cannot bring the trained dog with the intent of trying to gather sufficient evidence to get a warrant.
I think that's huge, actually, because normally in prior cases, the court has said the officer's intent does not matter. So like if you stop a car and you really want to search their car for drugs, and you say, oh, well, maybe there's a tail light out. I'm going to say I'm stopping him for the tail light.
Well, you have to have a pretext, though. I
Yeah.
mean,
But what the reason why the officer is stopping them is irrelevant. It doesn't matter why you stop,
That's
as long
right.
as they had the right to stop you.
That's correct.
You know, so that seems to me that's a pretty big change. Where now we're saying, well, maybe the officer's intent does matter, whereas in other cases, when it comes to vehicle stops, it has not mattered in the past. That might be a pretty big change.
Yeah, I think it will.
It would make a difference if it was an anonymous tip. If it was a named source, would that have allowed them to get a warrant at that
so.
point?
Well, I mean, if they had a warrant, of course,
I'm
this
talking
this
about
all
the-
goes
I don't know.
away.
You said it was an anonymous tip, so they couldn't get a warrant. It's a name tip, would that get, because I don't know the law.
Just
I'm
having a
not
tip
lawyer.
is not enough for a warrant, is it? No,
It could be.
Phone call.
Yeah, it could be.
It could be if there's some indication otherwise outside the tip that this is a reliable tipster. You know, then that is enough to give you probable cause to get a warrant. But just, you know, anonymous tips are inherently unreliable because they're not giving you their names, so you don't know their credibility, you don't know their reliability. You have to have a little bit more. But if it's a tipster that you've been working with in the past and that has given reasonable and good information in the past, that in and of itself can be good enough sometimes.
Yeah, you have to demonstrate either that, based on your own personal knowledge, the informant is reliable, or you have to demonstrate that the informant was in such a position to know the facts
Yeah.
of which he claims, that reliability is indicated. This case, there are all kinds of issues. As the dissent notes, for instance, the defense takes issue with the fact that there was a search at all, especially with respect to detecting odors, claiming, I think rightly, that most of us have no expectation of privacy when we cook things in our homes, that the odors aren't going to,
Yeah.
I mean, I live in a condominium, I promise you the odors come out.
Oh, that's interesting.
So we'll just have to, we'll have to wait and see. The prior case that I talked about last year was United States v. Jones, the one where they put the GPS device. And that really shook the law enforcement world. This shift in focus, where the court said, not only is reasonable expectation of privacy the standard, but it simply was added to the old standard. It didn't supplant the old standard as we thought it did. We thought the Katz decision had reversed the old standard in a case called Olmstead. But the court's now saying it didn't, and it just added to this other standard of trespass, property-linked Fourth Amendment protections. So I think now, if you, without a warrant, unless you can show that it falls under one of the exceptions to the Fourth Amendment, like exigent circumstances, police are going to need a warrant to do a lot of things they did not need one for before, because it was clear there was no expectation of privacy by the person that they were trying to search.
Observation and a question. Observation is that there's a big difference between an officer walking up to a door and smelling marijuana and saying that's reasonable cause to go in, and walking up there with a drug-sniffing dog to the door. I think that there's a motive type thing that you're directing toward a specific outcome, and at least that's the way I'm reading it.
Yeah.
My question comes in. Let's say that it's an explosive-smelling dog. In our current political atmosphere, would that make a difference?
Well, again, it's based on a tip, so I think in that case, at least they would have some reason to get to the door.
Yeah, or all of a sudden we're gonna get a lot more lenient.
I don't
if all
think
of
a
sudden
dog's just
somebody
gonna
comes
randomly
over and
smell it.
I think
explosives.
exigent circumstances
Yeah.
would apply there. You've got a Bob sniffing dog that alerts. I think that gives you, I mean, that's an exigent circumstance. You gotta go in and find out what's going on.
Perhaps that's what works in the airports.
Right, exactly.
So the nature of the threat has an impact
Yeah, sure.
Oh, sure it does.
on the findings.
Especially
Sure
if
it
it's
does.
9/11.
Sure it
but
does.
Probably
That's-
always, yeah.
A police officer walks up to
That's the way I read it.
Police officer walks up to a door and hears somebody inside saying, I'm gonna blow your damn brains out. He doesn't wait for a warrant.
On that lovely note. Oh, sorry.
I was just curious, is this all search and seizure, or have you got time for a First Amendment question?
No, we got time for,
Which, yeah.
You are the fraternity advisor to an utterly obnoxious, but nonetheless within their rights fraternity at LSU. That I was actually kind of impressed that they knew about a historical event behind last week's Pong party, hung up the sign about the Kent State Massacre, and now they're being threatened with all kinds of administrative sanctions by LSU. While they can't be arrested for it, can a fraternity successfully defend themselves on a First Amendment claim for getting in trouble with the obviously Greek life, or is that?
That's just it. I think their fraternity has certain rules, and if they're in violation of them, that has nothing to do with the First Amendment. And if the university has certain rules and expectations.
what was said on the sign?
I'm glad you're used to massacres or something
Yeah,
like
there
that.
were, LSU was playing Kent State, and they made a
Oh, wow.
gratuitous
A
reference
very
to the
harsh comment.
Kent State Massacre, which I was kind of impressed that they knew about it.
Yeah.
Whether they're, I mean, I personally, I would think they'd be protected by the First
Yeah,
Amendment.
I think
was-
they
Those
would
aren't
be too.
fighting words, they, you
I
know,
think they would be too.
they may, it may
In terms
be
of being
obnoxious.
prosecuted in court, but what about just being punished by the
Well,
university?
that's
or by the
another, that's what I was
chapter?
getting, that's another issue.
Yeah,
That's another issue. The
Atlantic
university can-
Council
can-
probably has
Well, certainly the Greek
Suspend
organization
them.
could
Suspend them.
suspend them or do whatever, but even the university is a state actor, and they are covered by the First Amendment too. The university doesn't have the right to restrict people's speech just as much as the federal
So,
government
Sitting there
does.
and could drop the hammer on them, but.
Absolutely, sitting there could absolutely drop the
Oh,
hammer
yeah,
on us,
yeah.
with no doubt. LSU, that's a
That's
trickier
a good point.
situation.
Share with the public.
They may not be able to.
That's a big issue in a lot of college campuses, is,
And as long as it's not seen as disruptive, I mean, the courts have said in the
Well,
school,
that might have been kind
and
of
it may have
disruptive.
been, I mean, that might be the defense, you know, the Supreme Court has said in the school setting, your free speech rights are a little restricted in that you don't have the right to disrupt the school environment, but I don't know if that would
Does
reach that far or not.
Does the current sauce have the same freedoms that the New York Times does as
Well, that's
opposed to
been
a high school
decided.
newspaper,
I
which
think so,
clearly
pretty,
does not.
high school
think
does
so.
not, but yeah.
I would think
So
so.
the current sauce can tell Dr. Webb to go, you know what?
Sure,
well,
sure,
Well,
absolutely.
Actually, I'm not sure about, I mean, you guys are the lawyers, but the fact is that Northwestern publishes the current sauce. That makes them, in effect, the owner. Just with the New York Times, you can't say in the New York Times, I
Well,
think the owner of the New York Times really sucks.
That's a good point, actually.
The
You
same
might be
standards
right.
would apply for
I don't know how that would
slander.
work.
Now, if
Yeah.
somebody on their
Libel.
own publishes a student
That's
newspaper
a good point.
without Northwestern funds, then
Yeah.
yeah.
That's a good
they
point.
would-
What do you guys think? You think that the local school newspaper ought to be able to say Northwestern sucks, or Professor Lange's got his head up his rear, or, which actually was written on the black, but that's What do you think?
I always heard the truth was a perfect defense, so.
Not asking you, not asking you. I'm asking smart people. I'm asking the gentleman with his
Morgan, yeah.
hand up.
Would it matter that the student newspaper is funded entirely, or I think it's entirely by student fees?
That's a good
I
point.
think that does
Good
matter.
question, yeah.
I
That's
think
an
that,
excellent point.
I think that does matter, yeah.
Oh, if they published an article that was somewhat critical of the financial aid office.
I think it would matter if the article has merit or not.
Yeah,
And not, it's not.
It would have merit when
Yeah,
it published
slander.
it
Defamatory.
on the week that the freshmen were coming with the parents and everybody, and there was the thing on the front page.
Right.
The administration probably wouldn't like it, but I would think the school would
And
be
there
well
is
within
an
their rights.
advisor, so the
Yeah.
advisor would probably advise against it.
Yeah.
If they had tenure.
But I think I think it all boils down to where does the money come from and who is the ultimate official head of the current sauce. And I think if it's run by student fees with student money, then they are separate from the university and they can say whatever they want to. But I think that, I mean, I just don't know if that's the way it is or not. But
By show of hands, how many of you think that
If
the
it goes
school
down to the journalism
newspaper
department, that's different too. I mean, that's
can
an
say what
as a
they want to?
school.
College.
How many of you think the school newspaper ought to be restricted in what they can say?
some big free speech people here, I like that.
All right. How many of you want the school newspaper to say classes are suspended for the next week?
On our next topic. Charlie, what you got for us?
Okay, moving right along. What I'm going to talk about today is the decision that probably got the most publicity in this past the two decisions together, they got the most publicity this entire Supreme Court term, and that was the decision on gay marriage. There were actually two decisions on gay marriage. One was Windsor versus United States, and the other one was Hollingsworth versus Perry. And those decisions, there was great anticipation that there would be a sort of a final decision, that we would have all of these ends wrapped up. We would know what the law is definitively, one way or the other, on gay marriage, and we were sorely disappointed. That did not happen. Although there were small victories in favor of gay marriage, there are things that are included in those opinions that have given some gay marriage advocates some pause and say, well, maybe there's some hidden traps in here that's going to stop our victory where we are now. The Windsor case, I'll start with the Windsor case. The Windsor case involved a couple in New York, two women who were legally married in the state of New York. They were one of 13 states who recognized either civil unions or full-on gay marriages. It was a case where one of the spouses died, and the federal estate tax law says that if you are a spouse, you don't have to pay inheritance tax. Well, there's a law out there called a federal statute called the Defense of Marriage Act, DOMA. And the Federal Defense of Marriage Act says that regardless of what the states say, we define marriage as one man and one woman, and we will not recognize any marriages other than those that are by one man and one woman. So even though these two women were legally married in New York, they didn't get the benefit of the estate tax exemption because the federal government says, no, we're going to make you pay income tax, estate tax on this because we don't recognize your marriage. And the surviving spouse brought this lawsuit, and it went all the way to the Supreme Court. And she says, it's unfair that my marriage is recognized by the state of New York, but the federal government won't recognize it. And this was not small change either. They were talking something around $100,000, $150,000. They had a very nice house.
Big money.
Big money, yeah. And so the question before the court was, is it constitutional for the federal government to say marriage is between one man and one woman, even when the states say, 13 states say otherwise? And the Supreme Court in that case said that DOMA was unconstitutional, that was not going to be allowed. What a lot of gay marriage advocates wanted the court to say was, well, gay marriage is a fundamental right that everyone should be enjoying, and it's a matter of due process. It's a matter of your inherent privacy rights, that you should have the right to marry anybody you want to, and the state should not be able to say otherwise. And that is not what the Supreme Court said at all. They specifically said, we're not going there. We're not going to address that subject because people might get mad at us, and we like people to like us a lot, and we like making easy decisions instead of hard ones. Am I being recorded? Maybe I shouldn't have said that. But here is what they said. They base it on something called federalism. Federalism is the judicial and the legal concept that what powers that are reserved to the states belong to the states, and the federal government can't interrupt those. And powers that belong to the federal government belong to the federal government, and the states can't interrupt those. For example, only the federal government has the right to declare war. Louisiana can't go declare war on Syria. We don't have that right, okay? That's specifically to the federal government. The Supreme Court said that that in this particular case, the states, these 13 states, have made a decision. And marriage has traditionally always been something that states have regulated. The states have decided who can marry, when they can marry, the regulations involved in marrying, and the federal government has no right to interject themselves into a state issue. If New York says it's a marriage, then the federal government should say it's a marriage. And the Supreme Court said, but by enacting this DOMA law, the federal government entered themselves into the rights that states have where they had no business being. That was the first, and that was the important part of their decision. The other part was sort of what they call an equal protection argument. There's a provision in the 14th Amendment of the Constitution that says everyone is guaranteed equal protection of the laws. And the Supreme Court said this married couple who are legally married and have a legally binding and recognizable marriage in New York is not getting equal protection of the law from the federal government. My marriage, as a heterosexual, is absolutely recognized. Their marriage, which is just as legal, is not being recognized. And they said that's not fair, but that only applies to those places that have recognized gay marriage in those states. So that only applies in 13 states. So in those 13 states, that's a very good opinion, and it's a very good decision, and it's a step in the right direction. The problem is there are 37 states right now that still define marriage as between a man and a woman, and in those 37 states, this decision is meaningless. It meant nothing. So it's a good and a bad thing. The bad part from the standpoint, if you're an advocate for gay marriage, is because they went out of their way, the Supreme Court went out of their way to make this a federalism argument and to say it's the state's power to regulate marriage. The concern is that gay marriage advocates have is that, well, in the 37 states that don't have gay marriage, they're going to be able to argue now, hey, you have said over and over again now that states get to define marriage. We get to define it. It's ours. It's not the federal government. So don't make us change because you have said over and over, it's our right. So they're going to sort of use that argument against gay marriage advocates to say it's a state's power to do whatever we want to. And the federal government has said over and over now, and the Supreme Court has said it here, that this is a power for the states. If the states want, however the states want to define marriage, a state gets to define marriage that way. Yeah.
But surely somebody's grooming a defendant is going to move to a place like Louisiana. You've got Bob and Joe who are going to want to move to Louisiana and file a joint return when they file their taxes. Matter of fact, this has already come up. And they're going to invoke the full faith and credit clause. So I don't know if the Supreme Court was...
No, that's interesting enough because there's a provision in DOMA, another provision of DOMA that specifically says that states that do not have gay marriage are in no way bound to recognize states' marriages of homosexual couples. So DOMA specifically says Louisiana does not have to recognize a New York marriage.
But the court didn't decide that.
The court did not decide that, absolutely right.
And I think you're right. I mean, the full faith and credit, Article 4, Section 1 of the Constitution says, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state.
And that's why
We covered the 10th Amendment.
Dead for 30 years.
Yes, that's
or
right.
longer.
And that's why this gay marriage decision is so important. I have my doubts that the Supreme Court is going to make a nationwide gay marriage across the board because they are so
By
reliant
show
on what
of
the
hands,
states.
Just
And it-
curiosity, if I may, by show of hand, how many of you believe that gay marriage will be legalized in all states in the Union within the next 10 years?
Don't necessarily have to like it, but it's
Do
gonna
we,
happen.
yeah, can we say we hope so?
Some can.
Okay,
some-
okay, the rest of you don't. Then let me ask you this, I'm curious. How many of you would like to see?
If you want
I
to
mean,
answer.
to
You don't
those
have
who
to
are
answer.
willing
If
to.
you want to answer.
You don't have to answer.
You don't have to answer. Just curious. Okay.
Now, one other factor that comes up, of course, is the court changes personnel. These guys seem to live a long time, but they do die and resign and retire. Looks like the first to retire next, without any other maybe tragedy or something happening, would probably be Ginsburg. I believe she's the oldest.
Yeah, and she's had some medical issues.
She's had medical issues. She's hanging on. It depends on who gets to appoint her. If Mr.
that's a
Obama gets to
wash.
replace her, nothing really changes.
That's a wash.
It's a liberal over a liberal.
That's right.
If the next president is a conservative and gets to replace her, then that may, confirm the current, now maybe 6-3 even.
That's right.
On the court. Okay, somebody, Savannah?
A lot of that will also depend on the results of the next year's senatorial elections.
That's true, sir. Yeah.
Ms.
Sorry.
Ann?
States don't have to recognize, like, if somebody gets married in New York, a gay couple, and they go to Louisiana, it's not recognized. Can the states do that for heterosexual couples? If it's the.
How you mean?
Like, my marriage is legal or recognized in Texas and everywhere else in the U.S.
For some
Yes.
reason, Louisiana decides to not recognize her marriage. Can they
Like
do
you
that?
said.
No, they would not be able to do that because the Supreme Court has made it clear that heterosexuals have a fundamental right to marry whoever they want to. I mean, they've said that in the Loving versus Virginia case, in the case where they said it's illegal to say whites can't marry blacks. They have made that clear that heterosexuals have that right, and so Louisiana can't say, no, we don't like you two, you're a weird-looking couple, we're not going to allow you two to have a recognized marriage here. That is certainly not the case. Your marriage is legal in all 50 states if you are a heterosexual
But
couple.
you know, the Supreme Court has protected homosexuals in many other aspects of life. They protected them against police intrusion, as it used to happen. Police would break into the home if they'd find a homosexual couple engaged in homosexual activity. They'd
Texas,
arrest them.
was that Johnson, Texas versus Johnson?
It was unlawful, and the Supreme Court said you can't do that. These people have a right to live their lives the way they want to, stay out of their damn business.
That's right. It just hasn't extended to the marriage context yet.
Let me,
Of course,
if I
there's a
may,
difference. Right to privacy, which is more or less what the Supreme Court the Ninth Amendment, I think, they've basically picked out the right to privacy.
14th. Yeah,
14th.
14th.
But that's different in a private case because marriage is not only between individuals, it's also a public thing regarding things like inheritance.
Sure.
Property
Absolutely.
rights and
State
so
issue,
forth. So
yeah.
that's why it becomes
think it's
if it wasn't a
inevitable.
public issue, it wouldn't be an issue.
I'd be
Absolutely, yeah, well,
remiss
sure,
if I
Absolutely.
didn't.
And a lot of people want to keep it, in theory, a religious issue, and it's not whatsoever.
Yeah,
It's a state issue.
Absolutely.
Heather's two mommies get married in New York and move to Louisiana. Heather's two mommies lose their respective jobs and apply for Medicaid, which is a federally funded program largely.
Good to
Now,
go.
Heather would have a right to Medicaid, it's just no question about that.
Yes,
But one of the two mommies
would not.
would not, under the Louisiana law.
That's right.
It's a federally funded program. I wonder if that would be, and then Heather, the other mommy, claims equal protection and sues over it.
Right, I mean, at this point, at this point, the rule is, whatever the state says marriage is what the federal government has to say marriage is in that state.
So, Heather's two mommies get Medicaid in New York, but they don't lose.
Exactly right.
And they would not have standing to sue right now.
That's exactly right. That's the way the law is right
Yes,
now. That's
sir.
right, yeah.
So if a homosexual couple in New York adopted a child and moved to Louisiana, what then would happen to the child? Who would have custody?
That's a very good question, actually. I thought that may have been where you were going.
That's been fought out. I forgot how it came out, but DHH is really fighting having to issue a birth certificate with two dads on it.
I don't know the
And they
answer to
were-
that question,
They
because
were
that's
trying to
a,
do it and we refused.
It's a great question.
I think many of these cases are going to be seen in the
And I
next
have
few
no
years.
clue.
I don't know either.
Perry's hemorrhaging internally back there.
No, I think y'all are all dodging the bullet. This case is not going anywhere because of the military.
Oh.
Military rights of courted spouses. Once the military recognizes gay marriage, the states have got to fall in line.
That's a good point.
Actually, they don't. The Texas Louisiana Guards have told them to
Good
go.
point.
Well, that's the guards.
I'd be remiss, however, if I
So,
didn't
Air Force.
note that with respect to privacy, you can search the Constitution all you want.
It's not in there.
And you will not find it.
As regards adoption, though, I mean, first of all, that's complicated by the fact that can't you adopt children, can a couple adopt children even if they're not married or something? Because I
Sure.
know, well.
Not in Louisiana.
Not in all
You can?
states.
Okay, because I
You can't
know
Louisiana?
they
Not in
couples
Louisiana,
that
you
have
can.
children in the state of Louisiana.
I mean, it can't be an official parent, like state-recognized parent-child relationship. You have to be a married heterosexual couple in order to do it as a couple in Louisiana.
So in these cases, one person adopts and they just
That's,
say it's.
that's right. That's how it's been done in the past.
Okay.
So you get around that.
No.
So only one parent has parental rights in Louisiana.
Can I turn
But
the
that's a
subject?
good question. I don't know what the answer to your question is, and
Next to me is Shirley.
my guess is the fact that there's a child involved changes everything, and
And again, he's an attorney in our.
I would suspect that that would still be recognized in Louisiana, although I don't know that for sure. I'm
I mean,
just
what's the
guessing.
alternative?
That's right. What's the alternative? Break the parental bonds that have already been there?
Unadopt a child?
Unadopt a child? I don't know how you could do that. I don't know how you could do that. That's a great question.
CJHS.
Think about law school.
That was a good question.
Greg Granger.
Recognize the voice from the good old days.
That's right.
Couple going to
G-R-A-N-G,
Mexico to get a divorce, and most
Professor of
states
History
in the
and
United States
Political
don't recognize a Mexican divorce. You go there and say, divorce, walk in a circle 3 times,
Appreciate you
something like that, you're divorced.
Mm-hmm.
But, they
The
came
only
back,
course I remember
and
from
I think
college
it's
was
Nevada that recognizes the Mexican divorce. So then they got remarried in Nevada and came to Louisiana. So the situation comes in, while Louisiana doesn't recognize the Mexican divorce, it was forced to recognize the Nevada marriage.
Oh,
Full
wow.
faith and credit?
Yeah, interesting.
Or did they have a compact or something? Does that
Could
affect
be.
anything? Some compacts? This young man back here has a.
Oh, yeah.
Did you have a question? Oh, just wave it to me. Okay. Hello.
Okay. Sergeant Bob down at Fort Pope
Okay, another hypothetical. This is getting complex.
falls in love with a civilian, so not the first soldier to do something silly, though, it's the first soldier to do something silly with another guy.
was that?
Can they legally get married on post?
That has happened. That's already happened.
Is there marriage recognized in Louisiana?
I don't think it would be recognized in Louisiana.
No.
Gotta
Not
remember
yet.
now, the
Not
post
yet.
is federal property.
I
On
have to
post.
admit, I almost had a damn heart attack when I saw the marriage in the West Point Chapel. Oh, God, take me now.
It would not be recognized in Louisiana for purposes of inheritance or.
Right.
I want to
or
turn the
adoption.
conversation
Adoption.
to blood.
Fair enough.
Can I turn the conversation to blood?
Blood, okay, blood.
When will we talk about admissions?
Oh, admissions? Let's go to admissions.
Let's go to admissions.
Blood will wait.
Might be blood here too. University of Texas, okay, if you're in Texas, there's a couple of different ways of getting into college. First of all, by state law, for the public universities, everybody in their top 10% of their high school class gets admitted to college, okay? University of Texas enrolls or gets about 6,000 freshmen a year or so, 6,000 or 7,000 freshmen a year. You know, this is a huge university compared to ours, for example. There is the state law in place, but University of Texas has its own admissions rules. It does, after many years of different controversies, it does take race into account. It does have a favorable accounting, not very quantitative that I can tell, for minorities. But there are many other factors it considers as well: community service, GPA, ACT scores, et cetera, and so forth. Long time ago, the Supreme Court said race cannot be the only factor, cannot be the primary factor, but can be a factor in this kind of decision. Well, Ms. Fisher, a Caucasian, was rejected for admission in the University of Texas in the university's 2008 entering class. The poor dear had to go to her second college, LSU, and she was not happy about that.
Well, it is kind of
you can
a step down.
so, no comment on tape. She sued the university because she says she did not get in because of the race-based affirmative action policy. Now, what's missing so far in everything I've read on this case is her exact proof that it was the race-based policy that kept her out and not perhaps having a weaker GPA than she should or something like that.
I think they show statistically her versus the admitted profile. Granted circumstantial, but sir, it was pretty compelling.
Okay.
She outscored something like
It's not
90%
mentioned in
of
the
the
case.
admitted blacks.
It's not mentioned in the case, that particular. The district court for those of you, just a reminder, a refresher, remember we have 3 levels of federal courts, district, and then a court of appeals, which covers several states usually at a time, and then the Supreme Court, the court of last resort. The district court ruled immediately for the university. Just said, this is not a case, basically, a summary judgment. She appealed to the Fifth Circuit Court of Appeals, and they pretty much also held for the university. They said that previous Supreme Court cases have pretty much given the university wide latitude when it comes to this developing its own policy. So then it gets to the Supreme Court of the United States, and they disagree. They say that the university needs the phrase, what is it called, the strict scrutiny. In other words, they have to, they're not allowed a lot of leeway, a lot of discretion.
They have to show a compelling.
They have to show a compelling, which they thought they had. Their idea previously is that diversity, a diverse student population and faculty, et cetera, is a factor that leads to a better educational outcome.
And
being a student in a diverse university makes you a better student.
And the Supreme Court has said that's true.
Has agreed with that. Wrong one here.
I'm sorry, I didn't mean to.
That's okay. The problem is that the Supreme Court now says that they don't have that much leeway, but it didn't really make a decision. It sent it back to the Fifth Circuit Court of Appeals. It remanded back and says, you have to work with the university to come up with something new, come up with a better explanation. The university has to prove that its policy does create a better educational environment, and it can get pretty complex. I have a certain personal connection to the case. I have a cousin, very close to, who is the admissions officer. He is the director of admissions research at University of Texas. He wrote their affirmative action policy. He went to the Supreme Court and had to deal with all this. I asked him this morning, I sent him an email and said, can you update us? Where do things stand right now? And this is what he says. The Fifth Circuit Court of Appeals issued an order just this past Thursday. The case was assigned to the exact same 3 judges that had it before, Judge King, Higginbotham, and Garza. The court has ordered, this Fifth Circuit Court of Appeals, has ordered supplemental briefing that should address a number of issues. Now, the Supreme Court really sent back one question to the Fifth Circuit of Appeals, but now they're getting the university to provide this type of information. Whether, first of all, to remand to the district court, the first court that it went to, have them make another decision, perhaps, and hear the case over again. How, first of all, secondly, how to apply strict scrutiny. What does it mean? The Supreme Court says to do it, but doesn't tell you how to do it. What does it mean to apply strict scrutiny as opposed to what we're doing already? They thought they were being fairly strict. Then they even bring up questions of whether Ms. Fisher had a standing to sue. Ms. Penrod just talked about it. You have to be able to show injury. So apparently the Supreme Court or the Fifth Circuit Court of Appeals, which is coming up with this, is not convinced that she has proven, in my opinion, that the race policy what kept her out of college. Did she have a standing to sue? In my opinion, that had to be settled immediately by the district, but I've yet to see evidence that it was. So I don't know why they're bringing that up. And also how much deference to give to the university in their determination that a critical mass, the proper mix of races and ethnicities is what they're searching for. Are there any alternatives, workable alternatives to an affirmative action policy? Can something else be put together? And pretty much anything else either side wants to bring to the court's attention is how he sums it up. It's coming fast. Ms. Fisher's brief is due to the Fifth Circuit Court of Appeals on October 4th, coming up soon. The university's response to her is due October 25th, and then her reply to that is due November 8th. Oral argument will be November 13th in Austin, and each side will get 30 minutes. Guess where I'll be on those days? That's where my cousin will be. So everything is up in the air right now. It seems to me a lot more questions have been asked than what were originally asked.
Yeah, what the Supreme Court said essentially, what it said essentially is, look, the Fifth Circuit Court of Appeals just applied the wrong standard when it reviewed the admission policies of UT. The Supreme Court had already blessed universities trying to achieve a diverse student body. They buy off on the premise that that's in the best interest of students. and that race can be a factor. The problem is the Fifth Circuit Court of Appeals assumed that UT used race in good faith in its admission practice. And having assumed that, they then turned to the, Fifth Circuit then turned to the petitioner, to the woman, and said, okay, overcome that presumption. Show us how UT did not use race in good faith. And the Supreme Court says, that's the wrong standard. You can't do that. So they sent it back, and I think that's one of the main things that they're doing.
What I find interesting, though, is in reading this, they both rely on the same case. The Court of Appeals said we're applying the Grutter standard, and the Supreme Court said you're not applying the Grutter. So, and I guess the Supreme Court wins.
That makes sense, though.
But
That makes
that
sense.
Supreme thing, you know.
If they assumed that the admission policies or
Right.
process
Then that's not
was in
strict
good, use race in good faith, that's not strict scrutiny.
And I think this is one of those cases where, as Dr. Granger said earlier, it's going to be very important to see who takes whose place later on down the road, because there are 4 surefire justices right now that want to completely do away with this and say race can never be a factor in admissions, because it is any use of race, they say, is a form of discrimination, and it unfairly puts the white applicant at a disadvantage over something that they cannot control. There are 4 justices right now who are dying to say that and get that out. Roberts has said it over and over
Race
again.
has no rational connection to education.
Right, and so, but there are still 5, Kennedy still being the swing vote, that says, well, you know, we kind of agree with that, but there are still lingering effects of past discrimination, and in order to remediate those past discrimination, we need to give minority applicants a little bit of a push to even the playing field. And so that's why we have universities trying to give minority applicants a little bit of a push to try to help them, once again, level the playing field. In this particular case, I think this is interesting. One of the things, the only way you can give minorities an extra push is to do something that's very, very small and something that doesn't have a huge effect. Like what you cannot do is say, okay, the way we're going to do this is 10% of all of the incoming applications, incoming seats at UT have to be minority. Okay, that's way too much. You can't do that. In this particular case, what UT does is they say, okay, we're going to give automatic admission to the top 10% of all high school graduates and top 10% of their class of all high schools. And Ms. Fisher says, you've already taken care of race by doing that, because in Texas, as in a lot of places, there are majority white schools and there are majority African-American schools. And she says that you've already taken care of that. You're going to assure you're going to get a certain number of black applicants because you're taking the top 10% from all schools, which is not a bad argument, I think. But the Supreme Court and the Fifth Circuit haven't really latched onto that at all. They say, no, they can do more than that.
But what I find interesting is they said that, okay, yes, they reminded themselves, you might say, that race
That's right.
can play a part. It's one of many factors UT has.
Right.
But how do you quantify it? How do you know how much of an
That's
effect
the
it has?
problem.
How do you weigh
Right,
it
you don't.
against the other factors?
Absolutely.
Who decides?
You also got to, a couple points. One, we're talking African American. Well, last time I looked, you also have Asians. And I would not be surprised with an Asian student being able to more effectively challenge this than a white student.
Well,
and Hispanic as well.
And the Supreme Court has traditionally limited these extra pushes to African American students because in the past they have been
That's
the ones
what
that are the
discrimination
victim of insidious discrimination. We haven't had a tradition of discrimination against Asians.
Actually, we have.
Yeah.
Well, maybe not to that degree, I wouldn't
Well,
think.
put them in jail. No, but
We did, yeah, in World War II, we put them in jail.
Internment.
The Japanese, but I mean.
And
Well, yeah, but it
looking
still goes back.
forward, you know, with the recent decision, basically on the Voting Rights Act, in effect saying that the South was no longer
Right.
have to have all the.
That's another big one. we
Federal
should bring
overseers,
up.
yeah.
Yeah, we wanted to, but.
Which is now actually spilling over, because I know there's been a recent challenge, it hasn't been, no decision yet, but there's a recent court challenge to the voucher effort, or law here in Louisiana, arguing that it discriminates against African-American students. You have to get to court, federal government's okay for those areas, those parishes still under federal
Right,
desegregation
right,
laws.
right,
That's what I'm trying
right.
to
Even
say.
for the ballot, because it is public money.
That's right.
So,
Right.
the question is going to become then, that could lead, if the court rules in effect that,
You're free to go, yeah.
the segregation orders are no longer, the South is no longer under that, if they, by the extension of the Voting Rights Act, they extend it to education, then that's gonna have an impact on, I would think, on the college mission standards, because you could make the same.
The difference is that the Voting Rights Act is one act, but throughout the South, these are all individual cases. Natchitoches has a case, Red River has a case, Alexandria has a case, so it's been going on for 50 years. But I don't think there's one single law that the Supreme Court can strike down, because they're all consent decrees entered into as a series of different cases
Right.
with an entirely similar but different set of facts.
Okay, just more work for lawyers.
That's right. More money for us.
God bless us. I'm curious, folks. I don't see a blackface in this crowd. Now, let's say that you guys felt it was important to have a diverse group of students here on Constitution Day. The Supreme Court tells you that's okay, but you can't do it in such a way that race is the dominant factor. How would you do it? How would you get, say, 10 African American
Use
students
proxies for
here?
race.
Not you. How would you do it? How would you do it?
course.
Well, let's
Diversity.
let the students answer. How would you do it? How would you?
Make it attractive. I don't know. It's a voluntary thing,
Nobody?
though. I'm not sure.
Let
it
me
applies.
ask you this. Who's the only black Supreme Court justice? Who? Who is? You back way in the back. Thomas? And how does Thomas vote on affirmative action?
Against it.
Yes.
They're not listening to you.
Those are high
I
school
will
students.
point out too that
They're doing
this
good
high
behavior.
school is the high school students.
Oh, those are high school students?
St. Mary's.
Those are my
yes.
kids.
Well, they're smart high school students.
Yes, they are.
Are these high school students?
Want to do another?
It's a pretty damn old-looking high school student.
Yeah.
Are you really high
Look at the
school
Voting Rights
students?
Act thing.
Let's do that. Since we brought up the issue, I want to move on. We're going to wrap things up with Charlie talking a bit more about the Voting Rights Act.
Yeah, that was-
But take a look at the Supreme Court, SCOTUS blog, and the Supreme Court's list of cases. I've got one that I was going to discuss that I'll be using in my international law class next semester because, again, it's just an ongoing question of what can our courts be used for in terms of applying, enforcing international norms, international law, human rights. The Supreme Court took a pretty bold statement against doing so. So there's some interesting cases out there, but I think the Voting Rights Act is such a real turning point in American history in 1965 that honestly I was shocked even by this court's decision. So why don't you fill us in on that?
Yeah, the case was Shelby County versus Shelby County in Alabama. And that case concerned the Voting Rights Act. The Voting Rights Act is a very big statute that does a lot of things. But what it's concerned with is making sure that states cannot pass rights that affect the rights of people to vote or to make it more difficult to vote. Back in the 50s and 60s, you would have things like poll taxes and literacy tests that were designed to, really against African Americans, to be totally frank about it, to depress their ability to vote in large numbers. And the Voting Rights Act said, yeah, we're done with that. We're not doing that anymore. And they did something very profound and something that's really never been done before in the Voting Rights Act. And in Section 5, it says, we find there are 9 states that are really bad about using their voting rules to discriminate against African Americans. It is overt, they're not denying it, and we want to make sure that these 9 states in particular are going to stop doing this. So what the Voting Rights Act did was said, for you 9 states, Louisiana, Alabama, most of the Confederate states, anytime you want to pass a law that affects someone's ability to vote, you have to send it to the federal government and allow the federal government to approve it first. No law can be passed by you until the federal government signs off and says, yep, that's not discriminatory. And that was passed in 1965, and for the last, 50 some odd years, that has continued to be the law. If Alabama wants to pass a rule changing their voting, voter ID or The number of
Changing the
polling
districts
places
even,
are changing the districts. That's right. You have to get approved. Does Oregon have to do that? No. Does Maine have to do that? No. Alabama, Louisiana do. And Shelby County in Alabama was tired of doing that. They said, you know, this is unfair. We think we've moved beyond race, and we shouldn't have to do this pre-clearance. We shouldn't have to submit these things to the federal government first before we can enact our laws. Because anyone who knows anything about government doesn't do things quickly. They don't get in the next day, check, and okay, you're done. These things take sometimes years to pre-clear. I mean, it takes a very long time. And so they said this statute now violates the Constitution in that you're treating us as second-class citizens now. You're putting a requirement on us 9 states that you don't put on the rest of them for totally antiquated reasons. And the Supreme Court said, we agree. And now, and here's what they said. They said, we don't deny the fact that there is discrimination still out there. And we don't deny the fact that there is lingering discrimination out there that affects voting rights. We don't deny that. What we have the problem with is that there's no proof that it still remains these 9 states. Like some of the statistics they cited are, you know, voter registration among African Americans in Alabama went from 30% to 80% in the last 50 years. And that, you know, African American turnout is in the highest in some of these 9 states. The state with the lowest African American turnout is Massachusetts, which is in no way a conservative state. And they said, you know, we've moved beyond the fact that these states need to continue to be penalized. And this is unfair to continue to make these states second-class citizens. So what they said is, Congress, if you want to keep doing this, go ahead. You got to have a new formula. You got to have a new justification for why these particular states are being required to do this. You can't just rely on 1965 data and continue to do this. So now there's no more pre-clearance, and there won't be, and Dr. Granger can talk about this better than I can, but no Republican Congress is ever going to re-vote for this and say, yeah, you know what, Alabama, you do need to continue doing this. This is not working for us, Alabama. It's never going to pass the House of Representatives. So without this, any formula in place,
Well, at least not for a year, so.
Or even the Senate with the 60-vote rule.
Absolutely, even with the Senate with a 60-vote rule. So in effect, pre-clearance is over and done with. And now if Texas or Alabama wants to pass a law on voting rights, they can automatically do it. The dissent was very upset about it. You know, Justice Ginsburg wrote a very fiery dissent about this, and she said, you know, what we are doing here is getting rid of something that has shown to have been working. It has gone from 30% to 80%. That means the Voting Rights Act is working, and we need to keep it in. You know, and she said, you know, the analogy she uses is, you know, it'd be silly to get rid of your umbrella because on a rainy day because you're dry. Right? You know, the umbrella is protecting you from the rain. You don't get rid of the umbrella because it's protecting you. And she was very, very adamant that the reason why we have the Voting Rights Act has been shown to have worked, and we need to continue to do this. But going back to what we talked about before is federalism. The court relied on federalism, and it said, you know, once again, the federal government doesn't have the right to meddle in states' affairs. Alabama has the right to make any law they want to on voting because the voting within that state is their right. The federal government shouldn't be interfering into their decision making. Going back to federalism, says the powers of the states to do what they want to do. And they said at this point the federal government has went too far.
Yeah, but it's still left open the door, as I understand it, Charlie, for Congress to make a showing.
Theoretically.
That indeed the bases, there's a sufficient basis, a need for the legislation. What the court said was, you're working with outdated, as you said, you're working with outdated data.
Right.
You're penalizing these states based on 50, 60-year-old data.
Right.
So get your data straight. If you get current data and it still shows we need this, by all means. But I think Charlie's right. I don't think
that's
that's
just it. I
gonna
wonder how widespread it'd have to be. I find it interesting that it was a county that brought the case and not a state. It seems to be the Voting Rights Act.
Yeah, I don't know how the standing worked there either, but apparently the issue was over, it was a clerk of court who wanted to get a new voter ID law passed quicker, and they said, we need to be able to know who is who, and there's this law out here that we would love to have, but it's stuck with the feds.
But doesn't that open up to say now we have to look at every county and not just the states.
Absolutely.
And how's,
Per county.
that's just onerous. I
Yeah.
mean,
And then, and once again, we can't get Congress to agree on what to have for dinner tomorrow. I mean, getting them to agree on this, I mean, I
Yeah,
think you
that's
can
not
speak to
gonna
this,
happen. Yeah, that's
is
not
going to be very difficult in practice. Is it possible? Sure, yeah. But with a Republican House and a
I think-
Democratic Senate, I mean, it's not going to happen anytime soon.
more likely would be the Justice Department trying to find a way to do it,
Yeah.
or an executive order, but it's not gonna fly, but.
That's right.
Trying to manipulate things that way. I don't know
That's
if
right.
that's
Of
gonna
course,
go.
the ruling only applied to the pre-approval.
Right.
Certainly, any
That's
individual
right.
or group who feels that they have been discriminated against will just sue.
That's exactly
I mean,
right.
It'll
That's
go
ex-
back to the court.
That's exactly right. It's still illegal to use your voting laws to discriminate against a group. That didn't change at all. You're absolutely right.
So all you're doing is changing the burden of proof in effect.
That's right.
Right, it's
From-
not
from the
presumed.
Government or the state, I guess, proving that they are discriminating.
Back to a
the-
standing
the
issue.
person
That's right.
Proving they are being discriminated.
Right,
against.
exactly, back to a
You're
standing,
changing the burden of proof.
a 2013 standing, not a 1965 standing. I mean, yeah.
That's right, because under the old formula, we assumed Alabama was passing laws to discriminate against people. That was the assumption, right? And that's why we needed this pre-clearance for the
Pretty
federal
darn
government.
good assumption, too.
Well, and it was. Yeah, in 1965, that absolutely was happening.
Yeah.
George Wallace
Watch it.
wouldn't have made any bones about it. That's exactly what he wanted to do. But Alabama says that was the 1960s. It's 2013 now, and we've moved
We've
on.
been talking about states' rights. Just, it behooves us, I think, just to take a moment to understand where it comes from. It comes from Article 10 of the Constitution, which reads very succinctly.
Amendment 10.
The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. What it says is, if the Constitution doesn't grant powers specifically to the federal government, and if the Constitution doesn't forbid the states from exercising certain powers, then those powers are reserved to the states. And that's been ignored, in my humble view, and it's been encroached upon for the past, 40, 50 years. The federal
Yeah,
government...
Look how the states used it. I mean,
Well, that's true.
Yeah, there's a reason for it being encroached upon, because states were going above and beyond what we would see as legal rights for every American.
That's a fair point.
Keeping people from voting.
That's a fair
people from
point. That's a
decent
fair point.
education. I mean,
Well, that's why I'll point out, when the federal government does get involved in a constitutional amendment, a Supreme Court case, and sometimes in legislation in this period of time, it was always to expand rights.
Yeah.
And it seems to me a lot is going on now to turn things around, and that's what
Absolutely.
worries me, so.
Absolutely.
But not necessarily coming from the states.
No, I meant
From the federal-
at the Supreme Court itself, going back to
Well,
deference to the
actually,
states.
You can add the president or the executive branch with the NSA and all that kind of stuff. It seems like, in a sense, a lot of times it's the states now who are fighting for expanded
Maybe so.
liberty
Yeah,
as
yeah.
opposed to the national government, which is becoming, in some areas,
Right.
obviously not in others, but in some areas.
More
With the
concentrated.
NSA and the drones and all that kind of stuff, that's national, that's
Right.
federal government.
Well, but that's
state.
federalism again. I mean,
It is.
that was supposed to be their purview.
Absolutely.
Any questions, concepts, ideas, suggestions?
We know this has been scintillating for you.
But I appreciate you guys coming. And we'll do this every year. So next September 17th, roughly, we hope to see you again. Have a great night. Thank you for coming.